All right, folks, today we're going to be talking about selective incorporation and modern issues related to civil liberties and the Bill of Rights, kind of building on stuff that we talked about on Tuesday. Bybee, I'll be honest, this is not my favorite reading of the class because it's a law review piece. TLDR, and we'll go into much more detail about this. Incorporation is taking rights from the Bill of Rights and liberties and applying them to the state context. Historically, and I covered this a little bit on Tuesday, the Bill of Rights only applied to the federal government. It only protected you from the federal government, and it only governed what the federal government must do. So, when you say the right to bear arms shall not be infringed, technically that meant that only the federal government could not pass legislation that infringed upon your right to bear arms. Your state, South Carolina, could still say you can't carry a gun, and that was perfectly constitutional at the time. Incorporation is exactly what it sounds like that. Taking those rights and incorporating them into the law of the state. We'll go into that in much more detail. Hopefully by the end of class today, you'll have a good understanding of takeaways I think are a little bit hidden, but there are still three of them that I think are important. Incorporation is historically inconsistent and textually shaky. He argues that the road to incorporation as we see it now, where most of the rights and liberties of the Constitution are incorporated to apply to the states, was not always a certainty. It was not always a done deal. He starts talking about Barron v. Baltimore, this case in 1833, which we will go into more detail on, that basically says, no, the state and the federal government are separate. You have this, the court doesn't actually have this coherent theory of why the Bill of Rights should apply to the states, even after the passage of the Due Process Clause of the 14th Amendment. That's a much later development. Two, he talks about this thing called the congruence principle. And basically, the court now insists that once a right is incorporated, it applies identically at state and federal levels. So first we have this view that these rights and liberties don't apply to the states, but as soon as they do, they have to apply in exactly the same way. There is no nuance or variation between them. That uniformity, this congruence, the congruence principle, avoids a two-track system where you have laws that look a certain way at the state level but not the federal level, and it helps avoid confusion. But Bybee basically makes this argument that this is distorting originalist constitutional design. It is not exactly or at all how the Constitution was meant to work. And finally, incorporation, what this leads to is that incorporation shifts power towards the judiciary over the state. It expands the court's role in constitutional law dramatically. It makes itself the arbiter of which rights are fundamental, and by doing so, it allows it to enforce them against the states. In essence, incorporation centralizes rights protections into the Supreme Court, altering balance of power between the states and the federal government, in particular in relation to the judiciary. It basically props up the judiciary as potentially one of the most, or if not the most, powerful branch, when it should be a co-equal branch, in terms of the protection or dissolution of the rights and liberties of American citizens. I know this is thrilling stuff. I see you all doing heel clicks and jumping for joy. I promise this can't hurt you. This is the Constitution Corner. We've already talked a little bit about what the Ninth Amendment is. That's unenumerated rights. In the Constitution, it says, don't let the fact that we listed a bunch of rights make you think that you don't have other rights. You do have other rights. Amendment 10 also says rights that aren't stipulated in the Constitution are reserved to the people and the states. And Amendment 14, Section 1 is going to really be the crux of this entire lecture, okay? And I'm going to go over it now, and I'm going to go over it at least 2 more times during the lecture itself. This is the core engine of incorporation. The Citizenship Clause of the 14th Amendment nationalizes citizenship after the Civil War. Before the Civil War, people would use the phrase the United States are in terms of plural, right? You are a citizen of your state first and foremost. After the Civil War, you have this notion that the United States it is a singular entity, a national entity. Power is more centralized, and part of that is that you are a citizen of the nation first, not necessarily of your state. The Due Process Clause, then, is the core engine of incorporation. It becomes the vehicle for applying Bill of Rights to the states. The Equal Protection Clause requires states to treat individuals equally under law. It is a second Equal Protection Clause. We already talked about the first one. And collectively, this allows the court in the future to interpret the Bill of Rights to apply to the states. So let's talk about how they do that. So you have this case, Barron v. Baltimore, in 1833, in which the Supreme Court holds that rights under the Bill of Rights are only meant to restrict the federal government, not the states. Chief Justice John Marshall at the time argues that if the framers wanted the Bill of Rights to apply to the states, they would have said so in the Constitution. But they didn't, so it doesn't. The result of this is what scholars call dual citizenship. Remember when we talked about dual federalism? This is part and parcel with that. Dual citizenship. Americans are protected against violations of or their rights are protected against federal violations, but not against state ones. Basic freedoms like freedom of speech or protection against unlawful searches and seizures were not incorporated to the states and could therefore be violated. States relied on their own charters for this, and obviously this creates massive problems where a citizen says, well, I have these rights under the nation, but all of my laws that govern my daily life are coming from the states. So this sets the stage for change. We just need the catalyst for that change. And that catalyst comes in the form of the 14th Amendment. The 14th Amendment is part of a series of 3 amendments. They're my favorite 3 amendments, and I would argue they're the 3 most important amendments in the history of the Constitution. The 13th Amendment, which allowed for slaves to be freed, except under circumstances in which they're prisoners. The 14th Amendment, which has a whole bunch of good gobbledygook in there, and the 15th Amendment, which extended voting rights to universal male suffrage. But the 14th Amendment, passed or ratified in 1868, transformed the Constitution almost entirely. It first made all persons born or naturalized in the United States citizens. And I apologize for looking at my notes so much for this. I have direct quotes from the Constitution that I don't have memorized here, which basically nationalized citizenship in the way that I talked about it before in the wake of slavery. It also determined that no state could deprive anyone of life, liberty, or property without due process of law, or deny anyone equal protection of the law. Does that language sound similar to anything? Deprive anyone of life, liberty, and property without due process of law? Yeah, that's John Locke. That's also basically the Declaration of Independence, too, which was plagiarized from John Locke. So yeah, we're finally getting stuff from the Declaration of Independence, almost word for word verbatim, into the Constitution. That's pretty cool. The Privileges or Immunities Clause seem to offer the most natural tool for applying the Bill of Rights to the states. However, this thing happens. It's a series of Supreme Court cases in 1873 called the Slaughterhouse Cases, in which the court just entirely gutted the Privileges and Immunities Clause as a way of a vehicle for bringing the Bill of Rights into the states. Basically, the Slaughterhouse Cases were a series of cases that I'm not going to talk about how cases get consolidated in the Supreme Court. That's too complicated. Take a con law course if you actually care about that. But Basically, a bunch of butchers in New Orleans were subject to a bunch of local charters that allowed for consolidation of authority of the butcher and slaughter industry of meat under certain larger slaughterhouses. And what they were forced to do, they argued, was tantamount to slave labor. Basically, under these new rules and regulations that were passed in New Orleans. And they said that the 13th Amendment applied to them. The issue here was that the plaintiffs were white. And so the court views this, they say, hold on, labor's getting involved. We're worried about some cross-racial coalitions here of poor people and upstart businesses. We can't have that happen. So what we're going to do is we're going to say, no, the 13th Amendment only applies to former freed African slaves. It does not apply to anything else. Anything else. And also, this Privileges and Immunities Clause does not fulfill any of these requirements that we were talking of here, right? So it doesn't incorporate these rights into the states here, particularly your rights under the 13th Amendment. That was a one-time thing that we did with the 13th Amendment. We're not going to apply it again. This history I go over in detail here, and it might be a little confusing, but it matters. And here's the takeaway with that, is that incorporation rests not on textual clarity, because I think it's fairly clear in those cases, and there are many judicial scholars who know more than me who would disagree with me here, that perhaps the plaintiffs in the slaughterhouse cases did have something to argue there, or at least there was more of an open door there to talk about how we incorporate these rights and liberties into the states. There was text there that could be interpreted that way. So it's not so much about textual clarity, but it's about judicial creativity. Remember, Supreme Court justices from that lecture on the Supreme Court, they're people too. They have their own political agendas, and they're subject to the same political forces that other political actors are. So in giving them this authority, this judicial creativity, it also shapes how these rights are incorporated to apply to citizens. So finally, answering our friend's question, what is selective incorporation? Basically, selective incorporation means that the court evaluates rights one at a time to decide if they're fundamental enough to apply to the state. So we take one right, one piece of the Constitution at a time, and we say selectively whether or not they incorporate into the state. That good? Yeah? Yeah? Okay. As I said, the vehicle for this is the 14th Amendment Due Process Clause. Over the 20th century, the court incorporated almost all of the Bill of Rights, especially under the Warren Court. The Warren Court was the court under Chief Justice Earl Warren. They decided Roe v. Wade and all of those good things. Was that the Warren Court or was that the Burger Court? Somebody look that up and then tell me I'm wrong. But not all provisions have been incorporated over this time either. And that the view that all rights should be incorporated is a philosophy that we'll talk about before the end of the lecture called total incorporation. We don't have total incorporation. Note that this approach is doctrinally messy, right? It's inconsistent by design. Selective incorporation means selective. They are selecting individual rights on a case-by-case basis to incorporate them to the state. They do this through several tests, right? So basically, the modern test for whether or not a bill or a right should be incorporated to the state asks, is the right fundamental to our scheme of ordered liberty? And two, is it deeply rooted in this nation's history and tradition? Is it fundamental to our scheme of ordered liberty? And is it deeply rooted in this nation's history and tradition? Fundamental to our scheme of ordered liberty, is it fundamental to how we view American liberty and democracy? Going along with that, is it deeply rooted? Is it a part of our common conception of how America has developed and how it acts in practice? If yes, that right is incorporated to the states. Once it's incorporated, the court insists it applies what they call jot for jot, exactly the same way state-wise as it is federally. There is no watered-down version for the state. So some states might argue, well, we want less extreme incorporation. It doesn't work like that. If it gets incorporated, the whole thing gets incorporated. And this is the congruence principle that we talked about under Bybee, by the way. So, different way of thinking about it. I want you guys to think about incorporation in terms of a timeline, right? So if it's messy and inconsistent, it's been messy and inconsistent over time. And piecemeal, we've gotten stuff incorporated, right? So first, we have the incorporation of the freedom of speech in this case called Gitlow v. New York in 1925, making it the first time that the court says that the First Amendment is bound up to the states, opening up, because we have this congruence principle, the incorporation of other First Amendment protections. Second, you have Meir v. Minnesota in 1931, which strikes down prior restraint under state law and incorporated the freedom of the press. In DeJong v. Oregon in 1937, it incorporates freedom of assembly. And finally, in criminal law, you have Mapp v. Ohio in 1961 and Gideon v. Wainwright in 1963. Mapp v. Ohio applied the exclusionary rule, which is talking about evidence procurement. Basically, evidence that is produced unlawfully can't be used against you in a court of law. So, like, a cop can't plant, drugs on you when they pull you over. That's illegal. Fun fact, if you didn't know. Don't let a cop plant weed in your car. And then in Gideon v. Wainwright, that's the case that guaranteed your right to counsel. And this timeline just goes to show that over the 20th century, you see these domains that were historically governed by the states. You see the federal government and the court in particular start seeping into these areas. Now, there are some things that aren't incorporated. Not now, and some of them that will never be incorporated. For instance, grand juries. Grand jury indictments still don't apply to the states. I talked about grand juries on Tuesday. The Seventh Amendment civil jury trial guarantee doesn't apply either. The Third Amendment, that's undecided right now. So these two deal much more with federal courts, so it doesn't really matter so much. This one, the quartering of troops, is currently undecided. So far, it does not incorporate to the states. However, I would argue that in the next few years, we are going to see some ripe cases involving the Third Amendment in the state, with Donald Trump sending National Guard to certain cities. I am certain that we will see more Third Amendment cases coming up, particularly under violations of the Posse Comitatus Act. The Posse Comitatus Act is forbidding the sending of troops against American civilian populations. And then the 9th and 10th Amendment haven't been incorporated because there aren't really specific separate rights that they talk about, so it doesn't really make sense for them to be incorporated, right? So, like, the 9th Amendment says that you have other rights that aren't in the Constitution. So, like, how do we incorporate that to the state? We're just like, hey, guys, the concept of rights is incorporated to the states. And then the 10th Amendment literally just says rights not listed here are reserved to the people or to the states. So it's saying that the states have rights incorporated into them, and it just doesn't make sense linguistically or actually. Now, I told you I'd get here. Total and selective incorporation. So, Justice Hugo Black, depicted here looking kind of like a frog, I guess. He's got like those eyes that look like they blink separately, like there's a guy on TikTok who does that. I think he's pretty funny. Anyway, so Hugo Black, he champions this notion of total incorporation, which basically is a straightforward way of applying the First through the 8th Amendment directly to the states in their entirety. He worried Not necessarily that it doesn't make sense not to incorporate them or anything, but that selective incorporation gave judges and justices too much power. So we just need to have a clean sweep of what goes in there. If we're incorporating some of them, we got to incorporate all of them, kit and caboodle. The court, however, sticks with selective incorporation and identifies only certain rights as fundamental. Remember those tests that I talked about, right? If it meets those two criteria, right, then it can be seen as fundamental. So if it's fundamental, of course it has to be incorporated. A few scholars argue that the Privileges and Immunities Clause is the hook for incorporation, not the Due Process Clause of the 14th Amendment, but they do have to contend with the precedent of the Slaughterhouse cases, which said that that is actually not the textual hook to incorporate rights in. And the court, to this day, stays selective. We don't often now see too many cases that are about incorporation, but we're going to talk about a few of them right now. So, there are two modern examples of incorporation with the Second and the Eighth Amendment. In 2010, you have McDonald v. Chicago, which applies the Second Amendment right to bear arms to the states. And then in 2019, you have Timms v. Indiana, where the court incorporated the Eighth Amendment's excessive fine clause, striking down state civil asset forfeiture practices. Civil forfeiture is basically a way that particularly police agency or police stations, thank you. Police stations take assets, as in property or money or guns or drugs, and takes them and uses the revenues from them, not in the case of drugs. Cops aren't selling drugs unless they're dirty, but selling property in particular to keep those assets, keep that money back to the public. Timms viewed that certain civil asset forfeiture practices in the state of Indiana were unconstitutional under the Eighth Amendment. Both cases indicate the congruence principle that we talked about with Bybee. They were incorporated whole cloth to apply to the state, and it just continues to show the doctrine's growth, right? So we have this Eighth Amendment case, we have the Second Amendment case, and of course, when we see that it applies to the state, it's got to apply the whole way. All right. There's a concept I'm briefly going to flag that I don't think you guys particularly have to remember, called a reverse incorporation. Reverse incorporation refers to the court using the Due Process Clause of the Fifth Amendment, not the 14th Amendment, to apply the equal protection principles of the 14th Amendment against the federal government. So basically, the best way to talk about this is in like the one case that it's really important in. Bowling v. Sharp in 1954 is like the companion case with Brown v. Board of Education, and they had to come up with this kind of confusing way of incorporating rights that they incorporated into the state, into the federal government, or rights for the individual into the federal government in order to desegregate DC schools. So Brown v. Board desegregated schools at the state level, but Washington, D.C. is under the purview of the federal government, so they needed to come up with a way of incorporating those rights there. That's basically all you need to know. Just write down Bowling v. Sharp. So, as with everything else, incorporation has effects for federalism. The big effect of incorporation is that it sets a nationwide floor for liberty. States can go above that floor, offering more liberties to their citizens, but they can't go below it. If a right is incorporated, that's the baseline. You have to provide them with those rights, or you can apply more, but you can't give them less rights. What this does, too, is it reduces state-by-state variation, and this can be argued that it's a good thing. If we are one country, you should have the same rights as you go across the state. There are also arguments that it's a bad thing. It limits the ability of states to practice their own independence. Litigation under these rights then shifts to state courts. So, right, if we have these conversations about rights and we know that they apply to the state, they don't need to go to the federal government every time to deal with their rights or their questions over their rights. That just goes to the state court instead. This also prompts state innovation. Remember when I talked about during the federalism lecture this idea of states as laboratories for democracy? This is a large argument in favor of that, right? If you have this floor of liberties and the federal government says you can go beyond these, and we as Americans want more freedom, then the idea is like maybe we want states to have this kind of movement. Like if we set the baseline, everybody is equal on this, so you go across the country, it's fine. But, maybe one state gives you more freedoms and then they innovate in some kind of policy way. That's pretty cool. Policy innovation is actually a really cool subset of the literature. I think it's really cool. I work on policy innovation and diffusion. That's pretty neat. So there are modern issues, and we already kind of talked about this a little bit on this. Free exercise principles pit religious liberty against neutral, generally applicable laws. Think about Masterpiece Cake Shop, that case here, where an individual argued that it was an individual liberty for them to exercise their religion and the state to not make a wedding cake for a gay couple. And that, of course, goes up to the federal government. If their free exercise of religion is protected and incorporated into state level, does that include denial of service? Speech and campaign spending, that's Citizens United v. FEC, right? If these rights are incorporated, the state of speech is incorporated to the state, and then money is incorporated as part of speech, then actors can do all sorts of things in terms of money and politics. We talked a little bit about digital privacy and due process. That is a very nascent form of legal scholarship out there. The court has not spoken a whole lot about digital privacy. There are like 2 or 3 watershed cases to this date that deal with that. I say, my unqualified opinion, that's because everybody on the Supreme Court is old as hell, and judges generally are old as hell, but that's just me. And then, of course, we have issues with incorporation of unenumerated rights, those being Dobbs. So, right, we have with Roe v. Wade what is basically an incorporation case where you say you have a right to privacy across all states of the union. You can get an abortion. That's fine. You have that right to privacy. What Dobbs does is it actually throws back that right to the states to decide. So it says the floor, right? You guys can't lower the floor, but we just lowered the floor, right? It's not that you have to provide protections for these individuals. If you go to Texas and Texas doesn't want you to have an abortion, Texas can say you can't have an abortion. We're going to leave that back up to the states here, right? There's no basis for incorporating some right that we say this in the text doesn't exist, right? So that's where that stands. Few key takeaways here. First, civil liberties are judicially elaborated over time. They evolve over time. The court interprets them differently. The 14th Amendment channels most of that. It is the driving force, particularly the Due Process Clause of selective incorporation. Most, but not all, of the Bill of Rights have been incorporated over the 20th century in particular. And when a right is incorporated through the congruence principle, it applies the same way in the states that it does in the federal government.